A cohabitation agreement can be an agreement drawn between the two of you and defines precisely the nature of your contributions towards the relationship, and in circumstances where the relationship breaks down, it provides certainty as to how certain assets or liabilities are divided between the two of you. Over the course of time, that may need to be amended to reflect changes in your relationship and the contributions that you make. Ultimately, it's to provide certainty to you both so that you know where you stand moving forward and avoids expensive legal costs down the line where there's a dispute. Cohabitation is the living arrangements between parties who are not married. So you can live with a partner and be in a relationship, but you're not married, and therefore you'd be classed as cohabitants. The law treats you differently if you are married or unmarried. You do not have the same entitlements or rights as a married couple. As a married couple, if one of the parties were to pass away, the surviving spouse would be able to make a claim against the estate of the deceased. However, as a cohabitant, you do not have the same rights as a married person would. This would, of course, make things substantially more difficult for you. As a married couple, and in the event of a separation, each spouse would be able to make a claim against the other's interest by virtue of the Matrimonial Causes Act. As a cohabitant, you do not have the same rights as a married couple. For example, whilst you may own a property together, that doesn't apply necessarily to pensions or to others' assets that they may have in their sole name. As a married couple, however, the starting point for a division of the matrimonial asset would be an equal split. Then it's up to either party to try and negotiate as to what would be a fair outcome for the matrimonial assets.